It's the same procedure that's applied. And the jury instructions kind of go into that, and I have to kind of apply that in this case. So I evaluate the testimony in light of my everyday experience in living life. And I have experiences with taking watches to be fixed, as I suppose most of us do. They break down, and you have to take them in to be fixed. And I know what your watch looks like. I mean, a watch is kind of an intimate thing. You wear it all the time. You look at it a lot during the day. It is kind of a personal thing to you, especially if it's given to you by somebody. I used to wear my grandfather's watch that he gave to me some years back, and you know that watch inside and out because it's a part of you, and you look at it all the time. And when you get it back from the jeweler's after you leave it there to have some work done on it, you can tell immediately whether it's yours or not because it's such an intimate thing. It's something that's important to you, and if it's not your watch, you know that right away. Even if you're in a hurry, you know that because of what a watch is. And in this case, the watch was given to you, Ms. Bacher, and you said you were in a hurry, but you said you at least looked at the band. You didn't say specifically whether you looked at the watch itself, but you did look at the band. I kind of find it hard to believe that you wouldn't have at least glanced at the watch. It's all one unit. And again, this is what people normally do, is they look at the thing given back to them. And apparently you didn't see any problems with it then, otherwise you would have said something. And so, you know, I'm left to conclude that, at least as of then, you were sure that it was your watch. And I think that if it were not your watch, you most likely would have said something at that time, because that's what people in general do. And I can bring that life experience into deciding this case because I live life, and I know that that's how people generally are, at least with respect to watches. In addition to that, there was some testimony that when you called Mr. Shetler, I think it was the next day, you did say that the size of the watch was different. It looked different. Now, there's some dispute here between the testimony as to how much of a difference in size there was. Mr. Shetler, your testimony was that Ms. Bacher said that it was a bigger difference in size than what you're saying, ma'am. But there was that testimony that, at least to some extent, is consistent between the two of you, in which there was a difference in the size of the watch. If there was that difference in the size of the watch, you had to have noticed that when you picked it up, especially for something that's so intimate as a watch. And again, if you noticed that, particularly if it had sentimental value, the logical thing is you would have said something at that time. Again, none of that happened. So when I hear the testimony, I am forced to conclude that the watch that was given back to you was the watch that you turned in. Now, maybe the watch that you turned in somehow got switched before you actually turned it in to the jewelry shop. Maybe you didn't know it. I don't know. But it seems reasonable to me to believe that the watch you got back was the one you turned in for the reasons that I indicated. And so for that reason, I'm going to dismiss the case. And I'll give this back to you, Mr. Shetler. Well, actually, you should get the watch back, really. It's your watch, I guess. And you can do with it what you please. I'll put it over here, Ms. Bacher. You can come and get it. But in any event, the case is dismissed.
Thank you.
Proof by the plaintiff is very important. The bottom line here is if you pay for something, make sure it's what you paid for. And if it's not, say something. Otherwise, good evidence may be lost. Now, let's take a look at the next case of Tears of a Clown.
When we got divorced, I was supposed to get the trailer that we were living in.
Okay.
And when I went to go get when I was allowed to get the trailer from the lawyer, I had to get the title first. When I got the title in the mail, I went to the trailer me and my daughter were going to move back in the trailer because we were staying at my mom's. And we got an eviction notice on the door of the trailer because Dave has a $1,560 $6.57 overdue bill, late charges on the trailer.
Okay.
So I had to, they were gonna evict the trailer. And in my divorce papers, it says that I'm allowed, he was supposed to leave the microwave, the clowns, the wooden stand. I have a clown collection. A wooden stand, kitchen table and chairs, bedroom dresser, candles in the stands, and pictures, and my spider lamp. I have a spider.
Spider lamp?
Well, it's a lamp that comes out
Oh.
like a spider.
Like a
okay.
spider.
And when I
Okay.
walked in my trailer, there was nothing in there except a ugly green chair that I would never own.
So was that your chair that you left there, or was that his chair?
It wasn't mine.
It wasn't there. Everything else was gone.
Everything was gone except the
The
chair,
ugly green chair?
the ugly green chair, and the dresser that has handles missing from it, knobs missing from it, and my the clothes or decorations or whatever was in a shed that he said that the shed was going to be locked up. Well, it has mold on the top of the shed, and all my stuff in the shed was wet.
Wet. From what? Rain?
Rain.
Let me see your judgment of divorce, ma'am. All right. It says here that the defendant shall sign over title to his 1989 Liberty manufactured home to the plaintiff, free and clear of any claim or encumbrances. Was that thing paid off at the time of divorce or not?
Yes, sir.
All
I
right.
just finished paying for it.
When did you finish paying for it?
Before we were divorced, it was
Oh.
paid for.
So when you signed it over to her, there was nothing owing on it?
No, it was clean and clear right there in front of her lawyer and my lawyer.
All right.
I handed it over right then at the divorce hearing.
What's this $1,500? What do you have regarding that?
I have late charge for the trailer
I
payment
mean, for the lot rent?
from the lot rent, yes.
Well,
And
okay.
they wanted to charge me for it before I could even go in there.
Who was supposed to pay the rental on this thing? Does the judgment say?
Yeah, it says that I was free and clear of that somewhere in there.
Well, it says free and clear of encumbrances. That's really not the same as lot rental. That has to do with the trailer itself.
What is going on here? I think she wants something to do with her trailer and something about clowns. Let's see if this gets any clearer.
Is there anything in this judgment of divorce that says who has to pay rent on the trailer?
I'm not sure.
No, I don't see anything.
I don't-
in there,
I didn't see anything when I looked at it for the first time quickly. All right, so I don't think that's an issue here. Now, it is further ordered that the plaintiff is awarded the microwave, clowns, wood stand, kitchen table and chairs, bedroom dresser, candles and stands and pictures presently located at 247 Corville Street, Warren, free and clear of any claim to the defendant. That's where the trailer was?
Yes.
And you're saying when you went in there, those items were gone? Is that
I didn't get, there was nothing in the trailer. No furniture, no microwave, no clown stand. The only stand that there was in there was a stand that you'll see the pictures.
Did you give me the pictures?
Yes.
Oh, here, all right. Is this picture gonna show that ugly green thing?
Yep.
Is that a yes?
Yes, I'm sorry.
Oh, this is that thing here, right?
Yes, sir.
You don't like that chair. All right, well, what about that? Mr. Stiltner, your ex-wife says that when she went to get the trailer, there was nothing there except that ugly green chair.
All right, going back prior to that, I had brought a lot of her clowns and pictures and stuff in bags when I was able to over to her house where she was living.
When was this?
This was before the divorce, when we were legally separated. I brought her some of her stuff. She complained to her lawyer that she wasn't getting her stuff, and she had opportunity for 2 months prior this date, October 30, whatever, 21st, to go over there and get all of the stuff that she wanted, and she never did.